and welcome again our guest, Martha Jo Patterson. She is an attorney. I always like when I bring attorneys and licensees, attorneys, CPAs, to throw the disclaimer out there. We are trying to give you educational information. We're not giving legal advice. I'm not licensed to, and Martha's just helping educate. Like going to ChatGPT, they don't give you legal advice. It says right on the bottom, I am AI and I cannot give legal advice. Consult a professional. Now, Martha is a professional, so if you want more information, you can call her, retain her, and get all the information that's good to get. Good morning.
Good morning. Good morning.
So let's talk about death.
I know.
Or maybe you can start off talking about what I think is probably one of the best gifts that anybody can give their heirs, a trust.
They can. Well, trusts are like fantastic because they avoid our fun probate court, which I think is fun, but somehow none of my clients really enjoy it a lot. Right now, the average probate, if you don't have a trust and your house is in your name and it's $1 million house, the statutory attorney's fees, I did the math, would be $23,000 and your executor could get $23,000.
And what does the state get?
And then you have court fees of $4,000. Well, the state usually doesn't get anything in terms of probate fees. The court gets filing fees, and they like their filing fees. They like a lot of money. Right now, it's about $500 to file a probate, and then you have to pay the publication, and you have to pay a probate referee. And it doesn't matter that your wonderful appraiser can appraise the house at X thing. We have to use a specific person hired by the state to appraise your house. It doesn't matter how many experts you have. That's the person. They're there, and you have to pay them. It doesn't matter. You just have to pay them in probate.
Interesting.
So it's called a probate referee to appraise your houses in both conservatorships and in probates. And that's a job. I have no idea how you get these jobs, but you send it to them. Now you can send them nice information from the expert, but you get to pay them. Even if they take that expert, they give that same exact number, you have to pay them. So your cost of a probate, people don't know, can be, I tell people, if on my scenario, it was only $4,000, which it's not going to be, you're at $50,000 if everybody in probate just, on your little $1 million house. And the $1 million house could be, built in 1955 and the old part of Fullerton. I mean, right now, because almost everything is, the median price of a house in Orange County is probably a little bit over $1 million now, but at one point it was $1 million. That's when I did the math. So when you die, you want to avoid probate, and trusts do that, provided a couple things. One, you have
Wait, go back 1 second, because there's a number that you missed sharing with me, and I don't know if it matters. So you got that $1 million hypothetical house that you talked about.
Right.
And you gave us roughly $50,000 in probate fees.
Right.
But what if I owe $975,000 on the house? Does that matter?
Nope.
Doesn't matter.
Does not matter to the court whatsoever.
So I can end up being the beneficiary, and I'm $25,000 upside down.
You could.
Wow.
Now, you're going to have a hard time finding anybody to take that probate because I want to get my fees. And if you're not selling the house and there's no money, then you could have nobody take that probate. And maybe if you don't pay the bill, eventually the bank will take it. But the bank could take a long time, because I have my neighbor and she's been gone now 3 years, and the bank still hasn't bothered foreclosing on her house. And the ne'er-do-well child still is living there. There's no electric and no power. And I don't think any of us neighbors are real thrilled with, what's living in that house other than him. We think that the rats in our neighborhood might be living in the garage and multiplying there.
Wow. So, okay. So now what's the alternative?
So the alternative is you get your living trust. So you get the living trust, but that's only part of it. So I'm on a crusade to make sure people avoid our probate court. That's not really a probate. So if I keep my house in my name and I die and I have a living trust and I never put my house in my living trust, it still has to go to probate court because I have to put it into the trust because it's in my name. So it's supposed to be in my name, Martha Patterson, as trustee of my trust. And then when I die, there could be a successor trustee who takes over, and then it doesn't go to probate. But if I don't put it, I always say trust works like a wagon. If it's empty, if that toy isn't in your wagon and you pull it around, it's not in your wagon. If your house isn't in your trust, so we go to court. Now, there was the case of Mr. Hegstead and then Mr. Uggstead. And under those cases, the court said, yes, we think you meant to put your asset in your trust, we're going to move it in. But guess what? People get trust from the online cheapy people, all sorts of these people, and they get it cheap. They don't put it in the trust. And there's nothing to tell the court that they meant to have their house put in their trust. And under those cases, we have to know that you meant to put your house in trust. And the court can say no, so you can spend the money for me to do that petition. And then the court says no, and you have to go to probate court. And one of our courts, now we're not in Ventura, but your radio show might go to Ventura. The Ventura court does not like these petitions at all and denies them. LA, much more friendly, Orange County friendly, San Diego friendly, Riverside, San Bernardino, a little less friendly, but still we're okay. But that judge has been trying to get all of his friends to stop granting these petitions. He's not succeeding, but I always worry, what if, he gets momentum and he says, oh, you're right. We shouldn't be just granting these petitions so easily. And then everybody's back to the probate expenses. And those petitions, I am now telling people, I'm going to charge you at least what I would have charged you for a trust to do that petition, if not more. And I get them, somebody's closing escrow. And in Orange County, it's about a 4-month wait to get into probate court. In LA, it's about 10 weeks.
Wow. When we come back, I want to talk to you about the difference in cost between getting a trust done and probate. And I also want to chat a little bit. Well, we'll continue that conversation when we come back. Continuing our conversation this morning, we are talking with Martha Jo Patterson. We're talking about estate planning. So before the break, Martha, we were talking about the concept of the trust and the probate.
Right.
What's the difference in cost, just in a real basic? I mean, I know not exact, but if we're looking at a basic, single residence, not a lot of investments, for a trust versus a probate on that same $1 million house you were talking about.
Well, so on that $1 million house, your probate is going to be $50,000.
Right.
Okay, that's if you go to probate court when you're dead. If you're alive and you can no longer write checks and say you have $1 million house and 100,000 in your savings account and a checking account, but you end up with a massive stroke and you cannot sign your name, and you end up in our lovely conservatorship court over in that probate, there is no level of limit of what lawyers can charge and fight over. And you could be paying 40, 50, 60, 100, 250. I have a client right now. Dad had a house and a rental property for his daughter. They rented to his daughter, and the family got in a fight, and they ended up in probate court. All the attorneys foisted upon them their combined legal fees in our Orange County Superior Court are over $250,000.
$250,000.
Living probate.
Wow.
And he didn't have a complicated estate, but he had a family that fought, and he had dementia and Parkinson's, and they didn't agree on what to do with that.
Ugh.
And they ended up fighting in court. And in our conservatorship court, I tell people it's like a divorce on steroids, because all the kids are fighting over really what happened, the estate when dad dies, but he's alive. And so all of his money goes to pay all the lawyers. And when he dies, now they all get less money. And there's no limit on how much all the lawyers get paid. And they get paid first, because we put that in place for ourselves. We always get paid first. In a probate, the lawyer gets paid first. The mortgage gets paid, then the lawyer. So then, and then everybody.
The lawyer's
else.
Actually, I guess, third.
Well, yeah.
My bet is
lawyers.
the government gets theirs first.
Yes, that's true.
Then we get the mortgage, and then the lawyers. From what you're saying.
Yeah, that's what I'm saying. Yep.
And what's the cost of a trust then in that case? If the trust was done, if proper estate planning had been done, what would that trust cost?
like I'm one of 10 attorneys who have dual certifications, and I try and keep my fees right below 5,000. But I am hearing from my friends that there are people less experienced than me. They're charging $6,500 for trust, which is fine.
Now you
And
have to
every
go back. You have to go back because I'm a simple guy. You said dual certification. What does that mean?
so I am California State Bar certified as a specialist in trust, probate, and estate planning. There's a specialist exam. You have to take a test,
Okay.
and then you have to get 10 people, including clients, to actually tell the state bar. They actually check your references. They have to give you references. Then you have to certify to them that you know you have done tax planning on uh, about 40 matters, and you have to name the matters for them to give you the certification. So not a lot of people. There are about 1,500 people in the state of California who
Wow.
have
That's a
done that
small
test.
set.
That's a small set. And then I'm also nationally certified as an elder law attorney. And the difference between estate planning and elder law, so estate planning focuses on avoiding death, avoiding taxes at death, planning for what happens when you die, all that tax planning, and a little bit when you live your powers of attorney. But elder law really focuses on planning for people as we age, our elderly population, our people with our special needs, our disabled adults, and what happens when you live. So I actually they have a dementia focused practice. I focus on what happens if you forget to die and live because I want people to avoid our living conservatorship court. Because if one day you wake up and you can't write a check, there's no magic genie out there that says, "Oh, we'll just let your wife write your check." Oh, you put everything in only Ron's name and your wife isn't on your checkbook. The law doesn't let her just sign your name. Same for your children. Just because they're children, they can't magically sign your name, so we have to go to court.
Wow.
I mean,
Okay.
people don't know
So
about that court. I mean, people, everybody's heard about death court. They don't realize, they might have heard a little bit about conservatorship court with Britney Spears, but the reality is until you're sitting because your loved one had that stroke or your loved one has dementia and they've been denying it for so long, by the time you try and help them, they won't accept your help.
now you had made a comment earlier, and I want to get back to that one as well because I had heard, and I'm not in the specialty. I'm just a radio guy that does a little lending planning or liability planning.
Right.
That the vast majority of the people who get a trust or have a trust have never funded them.
Yes, well, like I said, we were talking about those deeds. People get trust all the time. And they come to me, mom and dad are now both passed away. They come to me and they have a trust. And they said, "We've got a trust." And I call and have their deed pulled, and it's in mom and dad in joint tenancy. Well, they're both dead. Now we end up in probate court. Either I look at their trust. If I look at the trust and it was done by somebody who isn't an attorney who makes sure to make sure everything gets in the trust, like I do with all my clients, I go and, well, there's nothing in it. And there's no evidence. If you were a judge and I did a trust and I never even bothered to mention my house and that I wanted in my trust, would you think I wanted to put my house in the trust? You might not. So we may end up with a probate with that trust.
Now, the other area that I hear a lot about is people that take the house out of the trust to do a refinance
And it doesn't get put
and don't
back
put it
in.
back in.
Because I know it's counterintuitive because you do mortgages. Technically in California, it's not a technical mortgage. It is a deed secured by a note. Notes can only be signed by an individual in their individual capacity. That's why you have to have the credit for it. Trusts don't have any credit. I could be managing your trust as a trustee, so you wouldn't look at my credit. So you have to look at the person who actually owns the property. A trustee is not the owner, they're the manager of the property. So that way you have to take the property out, put it in the person who actually owns the property's name to finance it. Then the law allows us to put it back in, and that's fine. But a lot of mortgage brokers don't do that. People don't do it. It got it gets lost in all the hassle, and
And that
then
can be done in like seconds, right? I mean, as far as when you do the refinancing, the escrow company can
oh, they
take it out
can
of trust, do the loan, and put it right back into trust, all within that same
yeah,
transaction.
yeah, it could be done, and a lot of my better mortgage brokers do that, but it is really common that somebody has refinanced, they don't do that, and on that refinancing, my little bug because now with Prop 19, I'm having to do having people wanting to undo adding somebody on title to get credit, and now they're kinda stuck with a title issue when people die that doesn't always go like they want it to.
When we come back, I want to chat with you a little bit about Prop 19 because I don't know
Mm,
how it affects these things. And maybe even we'll chat, maybe we'll have time to talk about reducing income taxes
yeah.
as a senior. Continue our conversation. We are chatting with Martha Jo Patterson, an attorney, not giving legal advice, but giving us enough information for us to ask questions of those who do provide legal advice, like Martha does, when she's not on radio.
Yeah, yeah, well, yeah, yeah, no, well, I give information on the radio. I give information at my events, so
So tell me about Prop 19. What is Prop 19? Why? How does it pertain to our subject today?
okay, it pertains to everybody. So Prop 19 got passed a few years ago now, I would think it was now I don't remember the year, right after the Paradise Fires, and somebody came up with the idea of we've had Prop 13. Prop 13 keeps our property taxes low. We like our low property taxes. It keeps seniors like me from having our property taxes go to be so much we can't afford to keep our houses that we paid off because the property taxes were going up with the value. So it kept our property going to when we bought our house is not the current value. We loved our Prop 13, but somehow the guys who like to tax us in Sacramento don't like it so much. And I don't know who came up with the idea because everybody wants to blame somebody of Prop 19. Prop 19 gutted Prop 13. Now, we used to be able to pass between parents and children, uh, personal residences, and other property up to $1 million worth of value. And it was pretty generous, so people were passing 2 and 3 rental properties, and there might have been a little creative, appraisals to get that all done, but we were doing that, and people were passing inheritance property, and for the most part, nobody was they were keeping those low property taxes. Somebody said, "No, no, no." Prop 19 says that when I die, so I have my nice low senior citizen property taxes on my house that I actually inherited from my mother. So I inherited her property at what she paid for it, those property taxes. So I'm paying $2,000 of property taxes on a property that's worth about 800 because I live in a townhome, about 800,000, which would be right now about $9,000 in property
Right.
taxes. So I'm very happy, right? Because I got to inherit her low property taxes because she bought it for very little money when she bought her place. So now I'm the benefactor of that. That went away. Now the only people who get to keep those low Prop 13 taxes when you die are on your personal residence, and your child has to live in the property. If they don't live in the property, they don't get that. They don't get to keep the Prop
How
19.
long do they
So,
live there? Does it matter? I mean,
well,
does,
if they stop living there, then the property is going to get reappraised at the current value.
so if I move into my mom's house, my parents are passed, but if hypothetically, if I were to move into my mom's house under Prop 19, I can take on her property taxes and say I want to move into a senior home in 5 years. Just do my then they're going to go back and reassess it. Is that the idea?
That is correct. So as the
Wow.
the lower Prop 13 taxes only stay in place as long as a child is living in the home. Now, everybody says, well, how are they going to check? Well, there's a couple ways. Now, I know because we always figure out loopholes. You have to declare it as your personal residence. When your parent dies, and this is really important, if you want to keep that parent's home and keep their lower property taxes, you have to move in that year that they died. You have to move in, you have to intend to live there, you have to make that your personal residence. That has to be where you live. You don't get to have two on your income taxes. So one of them is your personal residence, one is not. So you have to tell the IRS and the assessors board that that's your taxes. And they want those tax forms done and filed in 90 days of death. Now, I know that I just said a year. Don't ask. The property assessors didn't listen to that. They want all those forms filed almost immediately after your parents die. So now, when somebody passes away, I'm warning people, and you want to keep mom and dad's home, you need to decide if you're going to have a child live in the home. Now we have that to keep those Prop 13 taxes. However, if you change title and you don't keep it among all the kids owning that house together, then the house gets reassessed because it goes from sibling to sibling, and there's a reassessment if one sibling buys the other siblings out then too. So that's been true under Prop 13. So we have to make sure in our trust, and I know everybody goes, "Oh, it's just so simple." It's just fill in the blank. But I need to make sure if we're going to have a home go to one child in the family, that we write the trust to authorize the trustee to reallocate assets among the heirs so one heir can buy out the others. Because if I don't write it in the trust, the wonderful property assessors will say, "Okay, you inherited the property when your parents die. It now belongs to all the siblings. One of you buys the others out. You're not buying it from mom and dad when they estate. You're buying it from each other."
So you have to do it through an equalization throughout the estate written in there.
Written in there, and it's or through some fancy, complicated mortgage stuff. But these are things people need to know because when their parents die and they leave a home, we don't have a lot of time to decide because those property tax assessors, they want that form in. We have that year. If we don't do it within the time frame, we lose that Prop 13
A lot of
taxes.
things to wonder. Now we don't have a lot of time left. Give me a couple items that where we can reduce income taxes as a senior.
Okay, so you told me earlier that your wife had inherited her parents' IRAs. And now under the Secure Act, for like 90% of people, that when they inherit an IRA, they have to use up that money in 10 years and they get taxed because we've deferred the taxes. So as they take the money out, they have a tax. So one way we can reduce income tax when you need care, there's an income tax deduction that hits at 7% of your income that you can deduct your medical expenses. You can deduct the Sunrise Assisted Living from your income taxes and from that withdrawal from those IRAs. So we can use that first and save a lot of taxes on the parents. People don't think of using their IRA to pay for care. They want to hold on to it. They're holding on to it. And we can save taxes. And there's a couple other strategies. And using that medical deduction, we can do that. We need to make sure if we sell a real property, that we consider that because that capital gains tax will come in as income and make your Medicare and everything more expensive. So if somebody has to sell their house for paying for care, as we need to always think, well, what are we going to do? We can't fix the capital gains tax, but can we do something to reduce the income tax?
It's amazing. There's so many different loopholes or strategies, I should say,
Yes,
that are
sir.
built into the tax code. And you've got to have somebody that's willing that understands these things and knows how to help you. If you want some information on this, give me a call at 800-306-1990. I'll put you in touch with Martha so she can strategize with you. And you know something? I'm a big believer that good advice doesn't cost you anything. You're going to get a return on that investment. And, if you don't do it, you might just write the tax check and say, "Oh man, my taxes were so much." Or you can go and hire somebody professionally who understands these things. And I'd rather give the money to Martha than give it to Uncle Sam. Just
Yeah.
throwing that out there.